I thank the gentleman, and now I recognize my colleague from Indiana, Mr. Rokita.
I thank the Chair, and I thank the witnesses for their testimony. I always learn a lot at these hearings, and I think that's what they're about. And perhaps unlike some others that were here earlier, I try not to prejudge them. But having said that, I do want to start off by offering some time to Mr. Lloyd. In Indiana, we have a saying that it's a pretty thin pancake that don't have two sides. And I think the actual quote is don't instead of doesn't. But if you had anything else to add to the recent comments of Mr. Foreman, you're welcome to say them now for a couple seconds.
Thank you. I actually know the facts of the Sidley matter better than Mr. Foreman because I was a partner at Sidley and Austin and on the executive committee at the time the EEOC brought that litigation. And I think Mr. Dryban made an error in suing Sidley. But in any event, I can tell you that on the one hand, we have the Sidley matter where the Commission approved going forward, and I understand why. And we have the PwC matter where, based on very different facts, the Commission made the decision not to go forward. And our facts are very similar to the PwC situation and very dissimilar from the Sidley situation. And I would like the opportunity, as I would have, for example, at the SEC, if the staff made a recommendation to proceed, to submit in one form or another, and maybe even visit with, to the Commissioners, the facts, so that they can make an informed decision about whether it makes sense as a policy matter, as a matter of whether this is a novel issue of law, and as a resource allocation matter. I mean, who are we going to protect here by initiating this litigation and tying up our staff time on this? And I can tell you, we take votes. Sidley Partners did not vote, for example. That's a very important difference. And my guess is that if at Sidley we had had votes taken by the partners on a routine basis for such things as electing leadership, that the EEOC at the time would have made a different decision and would not have authorized proceeding against Sidley.
Thank you, Mr. Lloyd.
Thank
this
you.
is to you and Mr. Dryban. In my prior public service, I was Indiana Secretary of State, and in that the great job, I had the opportunity to oversee several boards, appoint several boards, create into statute boards. Some boards, you know, were politically divided equally. 2 Republicans, 2 Democrats. That usually ended in a disaster. But some were all my appointments as a person being directly elected by the people, and then some had different varied degrees of political appointments. But they weren't necessarily partisan. It was just a way to decide things and to reflect the will of the people through their elected representatives. It seems to me in hearing this discussion that if you're having unelected attorneys, bureaucrats, whatever word you want to use, make these decisions, you're kind of tipping the scale of what the statute might have intended, the legislature might have intended in terms of the political appointments and how these decisions were supposed to be really made. Can you comment on that briefly, Mr. Lloyd, and then Mr. Dryban, same question?
Yeah, I'd be happy to respond. I agree wholeheartedly, and it has nothing to do with the competence of the attorney or the good faith of the attorney. Speaking as a general counsel myself, you know, I many times have oversight that sometimes I wish I didn't have, but I've found that over time, that oversight and getting differing opinions from people who are experienced and have different insights, that come from different backgrounds, have different points of view, is extremely valuable. I learn things. I then make different decisions on occasion from what I would normally do.
And then Mr. Dryban on the time I have remaining. Thank you, Mr. Lloyd.
Sure. Any law enforcement agency, no matter who they are, can become prone to overzealousness and excess. That's true of prosecutors, that's true of the police departments, and at times is true even of the EEOC. To deal with this issue, Congress created the Commission, a bipartisan commission of 5 people appointed by the President, confirmed by the United States Senate to serve staggered 5-year terms. No more than 3 of those 5 members can be of the same political party. As a result, the Commission, in the statute itself, is responsible for authorizing attorneys appointed by Title VII of the Civil Rights Act to appear in court at the direction of the Commission. Congress did not intend, and there's nothing in any statute to suggest that Congress did intend, for the Commission to delegate all of its authority about litigation entirely to other people in the agency, and that appears in practice to what has happened at the EEOC. In the same way, as I said earlier, that grand juries provide a check on prosecutors, even the most well-intentioned prosecutors, the Commission can serve and has historically served that same function at the EEOC.
Thank you, Mr. Dryban. Seeing my time's expired, Mr. Chairman, I'm yielding back, but I also would like to note for the record that the ranking member indicated that the hearing was only noticed for 8 days. That's actually a day extra day than what the rules actually require, and I would hope that the ranking member with 25 years of law practice would have read our rules.